Welcome everyone. I'm joined on the couches today by a select group of highly experienced individuals across the employment and HR and tax landscape of New Zealand. So we're here today talking to you about the essentials for any employer. So we've been running a series of seminars around New Zealand and we want to take the time just to go through some hot topics that we think employers really need to know and also really useful in the course of running their small businesses. So I'm going to start off with Mark. I'm going to ask you a couple of questions, Mark, about the exciting world of business transformation that's happening in Inland Revenue.
First, Scott, just to go back over what the Inland Revenue Business Transformation Program is all about. It's a complete end-to-end transformation of our customers, our people, our complete business processes, the policy that support them, and also it's about replacing our technology. Everyone seems to hone straight on the replacing technology. It's not about that, it's all about the above.
And so once that's in place, what are you guys looking to achieve through the transformation project?
The transformation project has got three key objectives. It's about growing the voluntary compliance amongst the users. It's also about reducing compliance costs for our businesses and also individuals and customers alike. And it's also ensuring that government are allowed the opportunity to implement legislation faster than it has been in recent years.
Yeah, sounds really good. I imagine, given that it's government, it's a pretty big project. So when you're looking like that rolling out? Yeah,
so the transformation program is a multifaceted, multi-staged release program. It's got 4 stages to it. The first stage is about ensuring secure digital services. Essentially, we've done some of that work already with MyIR and voice biometrics. The second stage is where we're starting to see some let's say, work that's been going on behind the scenes for the last couple of years. With stage 2 and 3, we start looking at the business taxes. We also bring into account the social policy stream. And in stage 4 is essentially whatever we've not considered under stages 1, 2 and 3 will by default be picked up in the final stages.
So if I'm an employer sitting here listening to that, what would I notice being different, or what impact do I think it would have on my business?
At present, we've been working with yourself and Xero with regards to filing of GST returns through software. So we've just gradually started to venture into new technology.
So as an employer or a business, what changes do you foresee happening in the PAYE area?
So the government have been recently consulting with the public. It started out last year. We had discussion documents around the Green Paper for digital services, and more recently there was a discussion document going out about better administration of POA and GST. We've received over 1,000 online comments with regards to that discussion document. We've had 86 submissions in written form. The policy team have got their work cut out right now. They're currently reviewing all the submissions that they've received around the discussion document. And it's fair to say, not one size fits all, so there's certainly plenty of food for thought for our policy team. They've got to compile that information and put some recommendations to the Minister no later than end of April next month.
So if a business is wanting to find out a little bit more about what's going on, can they go anywhere to find out, or is there any sort of information online anywhere?
Yeah, so we've got a URL, the makingtaxsimpler.ird.govt.nz, and if they click on that and just have a browse around there, they'll see all the information that's been published to date.
So that's really interesting, what's going on at IRD, and really starting to leverage this connected space we're finding ourselves. So I'm personally, from MYB's perspective, really excited about some of the things that we've been working on with them. I want to change gears a little bit now, and we've joined by Erin Spence, one of the labour inspectors from MB. And as we know, the changes to the Employee Standards Bill are coming into force shortly. So from an employer's perspective, what would be the key changes they need to be mindful of, or that might affect them?
Primarily, there's paid parental leave as a major factor. The increase from 16 to 18 weeks. That's going to come in regardless of whether or not the bill passes, because that was part of the budget. But the other parts of the parental leave that will be affected is just the entitlements. More people will be entitled to parental leave. It's gone to primary carer leave, so people who are involved with the likes of, say, whāngai adoptions or grandparents, so primary carers will now be able to be entitled to parental leave. And the other primary aspect is that the labour inspectors will have more powers, and so that means that we have more powers to ask for records. We can ask for bank statements, IRD statements, anything pertaining to an investigation that we might be a part of, and that will also mean that there's more labour inspectors can now issue infringement, so there's more penalties involved for non-compliance.
Okay, so it's really something that employers need to really take a look at and make sure that they're really aware of the changes. And so thinking about some of the things that you come across, in a practical sense when you're out visiting businesses, what are some of the common pitfalls that you see or mistakes that are often made by businesses in and around this, the employment legislation or record keeping, etc.?
Primarily, record keeping is the issue. People don't know what records they have to keep. They don't know they have to keep time and wage records. They think they only have to keep wage records. They don't know they have to keep holiday and leave records. They don't keep the records for long enough. After 12 months, people get rid of their records, where 6 years is the legislative requirement. People not recording hours. It's simply they say, yes, my employee works for 40 hours and don't record the hours, when hours may fluctuate. And if hours fluctuate, it obviously affects their annual leave calculations, things like that. And
if I'm wondering about some of this information or finding out about some of my minimum requirements, is there a place I can go and to find out, what I need to know, or is there a website I can go for more information?
So the new website is www.employment.govt.nz or newzealandatwork.govt.nz.
And if I'm right in saying there's a really great set of information and newsletters that comes out from biz.gov that has lots of really helpful information.
So that's the Employment New Zealand website now.
Yeah. Yep. So make sure you go out and subscribe to the newsletter that is on that website, because it's got lots of fantastic information. I subscribe to it for myself, and they pull together lots of really helpful information and tips from right across the spectrum of information that small businesses need to know. Thanks very much.
Thank you.
Erin. Right. So I'd like to welcome, as I mentioned, Chris Watkins, who's General Manager for People Safe. So Health and Safety Reform Bill, so when's that looking at coming into effect, Chris?
So that's been passed now
Yep.
and comes into force on the 4th of April.
So, what are some of the key changes as an employee you need to be aware of, Chris?
I guess the big thing around worker engagement, around the duties. So we've brought in the PCBU, so the peekaboo, so person conducting business or undertaking, the officer, and I guess the other people with the significant decision-making power, with the ability to influence what's happening out in the workplace. And then workers. So workers plus other people basically loops in my staff, my contractor staff, members of the public. The list goes on and on and on, volunteers. So we're basically saying, unless they've walked into your store to rob you, they're probably a worker.
From an employer's perspective, what does that mean that they have to sort of really check up on in terms of some of that understanding?
So some of the duties that come into place, and ultimately you could potentially fall into all three of those levels. You will need to know the duty that you have at each level, the engagement that you need to have at each level, and ultimately, I guess, the responsibilities that you have at each level. So it's certainly introduced that whole worker participation as the correct terminology behind it. We like to call it getting involved. So as simple as talking with your staff, engaging with your staff, getting them part of. So the traditional, I guess, health and safety was, I put a folder on a shelf from 2006. I feel like I'm covered because I paid $20,000 for this thing. But nobody else knows that it exists. Nobody else knows the rules in it, and nobody's taking part in that on a daily basis. So I guess from what we're seeing, the intent of the law is to obviously then bring everybody in, get everybody involved, and make health and safety an everyday thing that they're thinking about.
And I imagine too, the legislation comes with the bit of a stick.
Yeah,
So,
certainly.
we've
Certainly
heard a
a
lot
stick.
about it in the media. So what are some of the things that employers will need to be mindful of in that regard?
Yeah, so ultimately the fines for a worker have increased to $300,000 and up to 5 years in jail. Better still, you're a PCBU sitting at the top end of the tree, $3 million and up to 5 years in jail. So I guess they're certainly waiving that. I don't see that that's their intent to run around slamming people with that, but it's a way of enforcing, going like, we're serious about making a change here.
As a small business owner, do I need to be worried about it regardless of my size or industry, or is it really just
Yeah, absolutely. Common misperceptions going on in here. The old whispers started. We removed farming from being a high risk, and all of a sudden they didn't need to have a health and safety representative. I talk to farmers now and they go, oh no, we're not included in the law. Absolute myth. So everyone from one employee up obviously is still under the same law. Obviously going to have some smaller things to deal with than a bigger organisation, but absolutely they still need to deal with it.
If I'm a small business owner, I go, right, so I haven't got this in place. I've got to go out and contract an expensive consultant to give me the health and safety folder to put on my shelf. Is that what's happening these days?
Yeah, I guess another misconception. There are cowboys running around peddling their wares to get people 100% compliance. Internally, we're not even 100% sure what 100% compliant is. So, I mean, you can go out and spend some money if you like to, and there are companies running around spending a lot of money, and some companies, obviously the bigger ones, are going to need to, but certainly for these smaller guys, coming back to that worker participation and engagement, it literally is sitting down with your team, getting them actively involved, going, what's risky about the work that we're doing? How do we make it safer? And then physically putting plans in place to make that work safer, and then sharing it with everyone. It literally is that simple. So small business, sit down, spend some time doing it. It doesn't actually need to cost you anything if you didn't want it to.
There's some other things that employers need to be mindful of around, who's captured. Is it big injuries, small injuries? Is it walls collapsing, paper cuts? I've got twink in my eye. Like what are the things that people need to be mindful of from an employment perspective?
I guess in terms of the risk, they need to be capturing the big ones, absolutely. In terms of the information coming from staff, and I guess the intent of their law is then to be learning from these things. So giving people an avenue to talk, to experience, share their experiences with near misses, with accidents, incidents, finding new risks and being able to share that with you, and physically then learning from them, putting something in place so it's not happening again, is advancing the ball for them very quickly. And I think ultimately it changes the way people think about health and safety within their workplace, having the ability to voice their concerns about what's going on around them.
Yeah, and I think that's really important to make it pretty practical. This is, whilst it's extraordinarily serious, there needs to be a level of practicality for different businesses. In terms of like what's going to happen, how's this going to be policed, or what's the sort of enforcement side? You hear stories of going, like WorkSafe are working their way down the street and they'll be knocking on your business door next. So how's the practical side of that going to work?
Yeah, so I guess if you're ultimately being reckless, and that's where those high fines come in, if you're flouting the law blatantly over and over and over repeatedly, or you've got absolutely no safety plans in place, you've got some concerns to have. I guess how we're envisioning it outworks, if WorkSafe turned up to my work and they walked around and said, look, Chris, we've found these 3 things. Here's some thoughts. So we're going to put an improvement notice in place. Here's some thoughts about what we think you can do to change, how safe people are in this workplace. And then they left. If someone was to go dying or get seriously hurt at that point in time, and I'd kind of gone like, been doing this for 20 years, you boys don't know what you're talking about, you're all cowboys, go away. I'm probably getting fried, to be honest. If I've sat down with them and worked through that, taken that back into my workplace, got my staff involved, same thing again, back to that engagement, and then worked through that process and put some plans in place, I'm sitting in a fairly comfortable position, I think.
Doesn't it just mean that someone has decided there needs to be more laws somewhere, and so I've just got to do more work? So it's just like more onus on the SME to, cover across more red tape? Is this
Yeah. So certainly a perception
of
that, but I guess if you put in context, we're all pretty proud sitting here, All Black supporters. Amazing, they go and win the World Cup twice in a row, never been done before. We're actually seriously good at other things in New Zealand, and it happens to be killing people. So unfortunately, we're twice as good as the Australians and 3 times as good as the UK at killing people at work. So there had to be an impetus for change, and there had to be, a vast movement in that change to make something happen from that.
So what can employers do from a really practical sense, over and above what you said already, to really set themselves up for success here, and make sure they've got the key areas covered?
Yeah, so we're working with our clients. So we've got 40,000 odd clients. We're hitting January across the country now using PeopleSafe, just doing simple things. So we call it rejuvenating core safety values or habits. So just turning health and safety back into an everyday thing rather than something that Graham does down the hallway. So simple as, I've got them sitting here. So number 1, get involved. So back to that participation thing, getting your staff actively involved, listening to them, engaging them, telling your story, which we've covered, getting those reports from the incident, accidents, near misses, learning from that information. So it's all well and good reporting it, sticking it in a filing cabinet, but actually learning from that information. The third one's safety plans. Clearly I've brought it up 4 times now. So putting safety plans in place so everyone is aware of how we do work safely in this business. That's engaging your contractors and subcontractors and the people that are actively involved with how you work together, going, hey, when you're on my site, here's some things that you need to know about. Flow on from the safety plan, ultimately, check your skills. So know that your staff are trained and have the skills to do the job that you're employing them to do. Knowing that their certifications and their licenses are renewed and up to date. So the knowledge that they have around the risk that they're working with is at the best that it can be. I guess from there leading straight into that, check your gear. So if you've got people that are trained to do a job and they've got a safety plan showing them how to do that job correctly, if they're using gear to do that job, make sure that the gear's safe, checked and certified, because people using broken equipment are going to end up getting hurt. So very, very simple, but very core to the functions of an everyday business. So,
and it sounds like if you're in business and doing those things, it's actually part of running a good, solid business. So people shouldn't necessarily see it as a new set of impositions on their business. It's really what a business should be doing anyway.
Absolutely. Yeah. And I think that's removing that historic thing of going, and I keep mentioning Graham, but he keeps coming up down the hallway and turning it into an everyday thing, opening up that conversation and those pathways for people to talk. It becomes an everyday thing. So people talk about common sense and they go, isn't safety just common sense? It's a forgotten art, and it's something that we're trying to reinstall and bring back in to get people thinking and talking again. It really is that simple.
Thanks, Chris. Last point, if someone's wondering where to find out a little bit more information, or even indeed what PeopleSafe does to help us in the area, whereabouts can they go to find out more information?
So just via our website, so it's www.peoplesafe.co.nz. Lots of information on there, and there's a contact us link on there too if they want to come to us for more info.
So now we're going to move across to Linda Ryder, who's one of the directors at Goldstein Ryder, who are employment law specialists.
Hello.
Welcome.
Thank you.
So I guess, for a small business owner, thinking about all of these things we've just heard, it can be quite daunting to go, what don't I know? What are some of the things they need to think about if they're either starting out or thinking about that employment as the next evolution of their business?
Well, I think a lot of people have great innovative ideas and are passionate about a product or a service that they want to get to the market, and it's great if they can grow their business to the extent that they actually want to employ someone. I think at that point they should get some professional advice, whether from HR practitioners, employment lawyer. Their accountants are often a good first port of call as well, but to actually make sure that they are starting out getting a fundamental idea of what their obligations are, getting that initial paperwork set up in terms of what information do they need for IRD, what information do they need for employing people, an employment agreement, they must have that in place. So thinking through the things that they need from a documentation perspective, are they going to be a safety sensitive site? Do they need to think about safety plans? So actually doing the planning up front rather than employing somebody and then letting everything follow after that. So I think sometimes there's a bit too much rush to open the door, put out your sign and start trading without actually doing your legwork and your preparation first.
So what are some of the things from a duty of being an employer that someone needs to be mindful of? What are some of the areas you've got to watch out for as an employer or potential employer?
I think the key duty of in any employment relationship is the duty of good faith, and that's provided for in the Employment Relations Act, and essentially it is an obligation to be active and constructive, responsive and communicative in an employment relationship, and that concept of good faith underpins all of the behaviours in an employment relationship. So understanding fundamentally that obligation is really important. There's a number of other duties, duty to provide an employment agreement to ensure that it's signed, duty to pay the employee, duty under the Holidays Act to keep records of the time and wage records, annual leave records. So there's a whole lot of administrative obligations as well that go with being an employer.
So that sort of sounds from from a small business perspective, that sounds sort of quite, the first one in particular, the good faith duty. Talk to me about what that means practically from a small business employer. It sounds, in my non-legalese knowledge, that sort of sounds like a bit of terminology that I'd have to sort of decipher what it means. So in a practical sense, is good faith just meaning I shake the hand in the morning, or what does that actually mean in a really practical sense?
Look, I think it's indicative of the attitude that the employer has to bring into their business and in their dealings with their employee. So understanding that whenever an employer is proposing to make any changes in their business that could affect the employee, whether it affects their hours of work, affects their pay rate, affects maybe the day that they're going to get paid, anything that's going to have an impact on the employee, that the first thought that should come into their mind is, I need to consult with the employee, I need to engage in discussion. And it's not necessarily always a one-way conversation. It has to be being active, communicative and responsive. So not just saying no because of. So I think it's understanding that is a core obligation in terms of fostering and maintaining a productive employment relationship, and that's a statutory obligation as well. So there's an obligation to try to be, constructive and keep the relationship on the right track.
I guess a question that I get asked sometimes too when I'm out and about, and I know comes up in our Payroll Centre a bit, is who's covered by minimum wage? Is everybody covered? Is it someone who's a trainee or a youth worker? Are they all covered, or can we pretty much choose to pay people what we like?
Right. Well, so the Minimum Wage Act does apply to all wage earners. So it's basically setting a limit, threshold at which all employees must be paid. They can't be paid below that standard. So there are a few exceptions. One is for trainees and youth workers, but they are for limited periods of time as well in terms of trainees. So I think the limit might be for a period of 3 months or something like that. So it's not a blanket rule that you can pay under the minimum wage just because someone's a trainee or a youth. So do check out your obligations. You can search up the legislation and make sure that you're paying. If you're required to pay the minimum rate, make sure you pay it, because otherwise you'll have error knocking on your door saying up to $10,000 fine if you're a sole trader, $20,000 fine if you're a business.
Right, so it's definitely worthwhile finding out.
Absolutely,
we should be paying. So whose obligation is it in the workplace to maintain a safe environment from a legal standpoint?
It's the employer's obligation. Employees also have obligations, though, to protect or to ensure their own health and safety while at work. And as Chris mentioned, there are fines for individuals as well. So employees can be taken to task and prosecuted by WorkSafe New Zealand if they don't meet their obligations. But primarily the obligation will fall on employers to manage their work sites for employees, any visitors, volunteers and contractors. So a wide-ranging obligation to a number of people who having any dealings with their business.
One of the areas we have a question on here that's come in is really trying to understand what would be considered discrimination in the workplace. Have you got some things that employers need to be mindful of when they're thinking about either employment or working with staff members around what would be considered areas of discrimination?
Yep. So discrimination as a concept is really treating someone differently, usually more, unfairly or less favourably because of one of the grounds of discrimination. So because of their age, their marital status, their religious beliefs, their political beliefs, their colour, their race, their gender, their sexual preferences. So they are the sorts of things that are set out in the Human Rights Act, that you are not allowed to discriminate on those grounds. They're always very difficult things to prove because they're often not. An employer doesn't normally say, I'm discriminating because you're 65 and I think you should retire, or ask the question at an interview, are you pregnant or are you expecting, are you planning on having a family in the next short while? So I think that certainly in my experience, employers, the ones I've dealt with anyway, haven't gone there, so that's good. But it's just being mindful that you do actually have obligations under the Human Rights Act not to discriminate on those grounds. Under the Employment Relations Act, there's another category of potential discrimination, which is discriminating against somebody because of their involvement in a union. So again, that would be unlawful if you give them less favourable treatment because they belong to the union.
Yep, so you have to be quite careful then, in, particularly when it's in recruitment or talking about changes to positions, or being really mindful of not being discriminatory.
Yep, absolutely, because employees can take claims under the Human Rights Act, and the Human Rights Act in recent times have been making some very large compensatory payments to employees. I think there was one last year which sort of caused a bit of a ripple effect. The award was something like $100,000, which in the employment jurisdiction you just don't get figures of that amount, but there certainly is a real deterrent factor there for the human rights, trying to make their mark.
One of the things that comes up a little bit is who in the employment workplace is liable for damages caused by an employee. So have you got any sort of guidance around for employers around in this particular area?
Mm-hmm. So if an employee you send to work site and they damage someone else's property, maybe you're a landscaping place and you send them off to do some work and the employee manages to back into a fence and destroy it or something like that, ultimately that's the employer's obligation to make good that damage. Whether or not they can recover those damages from the employee will depend upon whether the employee was acting negligent, so they breached their duty of care in what they were doing, or the duty that they were doing was outside their scope of work. So let's say the fence had been knocked over by the labourer who actually didn't have a licence at the time, but he'd just jumped in to move the truck to help out the site foreman, so he didn't actually have authority to drive the vehicle. So something like that, the employer does have a potential to bring a claim for damages against the employee. Very rarely do employers actually make use of the weapons or the tools that they have, if you like, to actually bring claims against employees, but they do have some rights there too.
We heard before, and also from Erin, about the obligations around record keeping and the duty to keep employment agreements. So is it right in saying that you're able to enter into an employment agreement verbally?
You can enter into an employment agreement verbally, and there will be a number of employees who are working today who do not have written employment agreements, but who will turn up to work and who will be paid. So whether or not the agreement's verbal, there is still an employment relationship. the employer would be in breach of the Act by not having an employment agreement in writing and not having it signed by the employee, but that doesn't fundamentally alter the fact that the parties are actually in an employment relationship, and all of the rights and obligations that go with that would still follow.
Right.
Yeah, even if it's verbal.
Right. So I mean, the best rule of thumb is to always make sure you're putting in written employment agreements for all of the staff that you're working with.
Yep, absolutely. It's a statutory requirement. You must have a written employment agreement, and you must, in my view, and it must be signed, and the employer has to give the employee a copy of the signed agreement as well. Yeah.
Right.
So again, it's something that the labour inspectors are cracking down on, and certainly the Employment Relations Authority are dishing out larger fines for employers who are not yet compliant with that, because the rule's been around for a long time now. So as far as they're concerned, there's no excuse not to comply with that very fundamental obligation.
Right, so one of the things that I've never been that clear on is whether or not the 90-day trial period can be used as sort of a bit of a fixed-term contract. Is that something that is allowable?
A fixed-term contract as a concept is where you employ someone to work to complete a particular project or to fill in for a particular employee. For the classic is where you've got a maternity leave position and you need someone to cover while that person's away on maternity leave. So with a fixed term contract, it means that the parties can agree in advance when the employment relationship will start and when the employment relationship will end. And you have to comply with the Act in relation to having fixed term agreements. So you've got to have reasonable grounds based on sort of good, genuine business reasons for having a fixed term, because otherwise employers would maybe use that as a vehicle to avoid personal grievances, because you could agree in advance that the employment relationship is going to end on the 20th of February, and the employee wouldn't be able to bring a personal grievance claim. So as a concept, it's different from a trial period. If for the trial period, it can only be up to at the most 90 days, and it can only apply for new employees. The whole purpose of it is to give the employer the ability to test out or try out the employee, see whether they'll be a good fit, whether they're somebody that they want to employ during that 90-day period. So the concepts are different as to why you'd have a fixed term. You might not, as opposed to the trial. The trial period.
That makes it clearer.
Yeah.
There's lots of information to cover across today, but there's a couple of key takeaways that as an employer listening to this, and you go, okay, if you hear nothing else of today, what would you be encouraging employers to be really cognizant of?
Absolutely, written employment agreements. So make sure that you have all of your staff have written employment agreements, even if you're currently operating where you've got staff who've been employed for a number of years, still get an agreement drawn up, start the process of consultation around getting their terms and conditions committed to writing. It really is the cornerstone of the employment relationship. At the end of the day, is a contract, and what those terms and conditions are, what the obligations and rights are, should be recorded in writing, and then it avoids a lot of dispute later about, am I entitled to the ute? Am I entitled to a bonus? How many weeks leave am I entitled to? If it's committed to writing, then both parties know with some certainty this is what we've agreed.
Right, no, that's really, really good advice, and I hope all of you listening out there are actually making a mental note to go back through all the staff records and make sure you've got ship shape employment agreements in place. Otherwise, this one and this one will be on your case. So what sort of work do you do in the area of employment agreements yourself? Is that an area that your firm gets into?
Yep, so we have developed a series of employment agreements. So when we started our practice 5 years ago, there were 3 employment lawyers, and we said for the various situations that we'd come across at different times and different factual scenarios, if only we'd had a clause in the employment agreement that said this. So between us, and you can imagine how long it took with 3 lawyers arguing over may and they and will or shall, we came up with an agreement that we felt that gave us the tools, well, for our clients, gave them the tools to deal with some really tricky situations, particularly around medical incapacity, trying to get through the whole breach of privacy issues around accessing medical information, suspensions, restraint of trades, having a really good deductions clause to make it easier for the employer to deduct money from an employee if they owed money at the end of their employment and things like that. So we think we've come up with a pretty good agreement that's pretty robust.
Yeah, no, that sounds good. Well, so it's off to Goldstein Ryder if you need to sort out your
absolutely
of your employment issues.
Yep.
Thank you very much for that, Linda. So hand across to the last person on the couch.
Thank you.
Welcome Jason Enor, who runs a business called MyHR.
Cheers.
So just thinking about all of the things you've heard and you sort of again come across in the world of small business employment. So there's a number of sort of common pitfalls that you might see in that. In the world of employing people. So maybe if you've got a couple that you can
you're right. I mean,
share with us.
A couple. Yeah, how long have we got?
Yeah.
No, I think what I would say, and this covers a little bit too, to build on what Linda has said, if we go back to that question of good faith and think about it outside of a legal context. I mean, an employment relationship fundamentally is just a relationship between two people, like any other relationship. So for a relationship to work, there needs to be open and active and transparent communication. And the same applies. And that's really all that good faith is trying to put in law. So it stops an employer waltzing up and you're changing pay and conditions without talking to the employee. But it also builds on good practice in terms of keeping your employees interested and engaged. So if you want to include a water cooler, if you want to paint the tea room, if you want to do something, you're not legally obliged to talk to your staff about it, but why not? Why not engage them in what's going on in the workplace? And then that immediately flows into your obligations around safety. We're going to make some changes to this area. So we want your input. What colour would you like the walls? Where would you like the smoking area? Let's talk about whether that's safe. Let's talk about whether you're interested in that sort of stuff. And so for me, good faith has these sort of legal areas of, pay and conditions and consultation in regards to that, but also beyond that in terms of just a good, honest, open relationship. That's really when employment works. And the other thing about good faith that people often forget is it's a reciprocal obligation. So that means employees have to behave in good faith as well. They can't just go out there and sort of misbehave and do whatever they like and then expect that, everything comes their way. It's absolutely a two-way street, and the law is very, very clear about that. So that's the first point. We can over-legalise sometimes, and that's not to diminish what Linda was saying, but the day-to-day stuff of getting the job done and serving your customer or making your product, it happens outside of those legal conversations. These are human relationships. So that's a fundamental. I think in terms of pitfalls and common issues, this trial period one is really interesting, and building again on what Linda says, your question was on the money. I often get questions about, okay, so at the end of the 90-day trial period, their employment ends unless I say otherwise, and absolutely not. If you do nothing, the trial period just disappears and employment carries on. It is not a fixed term period of employment. You haven't engaged them for 90 days and then decided to continue them. You've engaged them as an employee on an ongoing permanent basis, if it's a permanent contract agreement. And during that 90-day period, you may determine that they are not suitable for your workplace for some reason. But if you do nothing and day 91 rolls around, they are still employed. And that is fundamentally different. And in terms of the reasons for a fixed term agreement, which as Linda pointed out are different, they must be commercially justifiable. And the law is quite explicit around saying you cannot use a fixed term agreement to try somebody out. So those, so trial periods, because it's relatively new law, there's this sort of idea that it's a bit like The Apprentice, you're fired. Get out. Doesn't quite work like that. So have a signed employment agreement, make sure the agreement is signed before the employee starts work, that they haven't worked for you before, that it includes a trial period clause, and the current trial period clause. We often see the old probationary period clauses with a new title on the top. Doesn't cut it. And also that the employee has had a reasonable amount of time to review that agreement and seek advice before they started with you. So that's one pitfall around, certainly trial periods and perceptions around it. Your good faith obligations still apply. It's not a march them out and, kick them up the backside and send them down the street. You still need to engage in a conversation, explain why, and then give them the right of reply and then move them on.
One of the things that I've had in speaking to various businesses that I've sort of mentored over the years is this concept of employer versus contractor. Oh, yeah, I've got 4 blokes. They
Mhm.
work for me. We've come to some sort of arrangement that they just work for me, but we sort of, they work 4 days for me, but they're contractors. But it works for both of us.
Yeah.
They only work for me.
Yeah.
But they're not staff, so I don't have to worry about all that painful employer stuff.
Yeah,
but
yeah.
it works pretty well for both of us. So. From my meagre reading of the legislation, I would have suggested that they're more likely to be employees than contractors.
Yeah, they will. And so my approach to these sorts of things are, again, as a non-lawyer, is to kind of unlegalise it. And really, if it walks like a duck and it quacks like a duck, then it's a duck, right? And so there are two, and it's great that we got the IRD and MB here, because these are the two bodies that care about that.
Yeah.
The IRD do not want people as independent contractors paying or managing their own tax, or failing to, when they're in fact employees, and PAYE should be deducted. And MB and labour inspectors, they care about this when the relationship ends particularly, and the contractor is sort of kicked to the curb, and things like leave records and entitlements are not granted to them because they're deemed a contractor when in fact they were an employee. So what I will say, because we could talk about this for ages, the IRD website has a great table that compares the two in bullet points. An employee does these things, and a contractor does these things or has these things. The ministry also has one. Use those, and don't try and fool yourself. If it feels funny, in our experience, it's generally always then defaults to an employment relationship. And we use 2 tests I like to use, which are a little informal, but it's the leave test and the termination test, right? So the leave test is, if somebody comes up to you in your organisation, says, hey, Scott, I'm off for August. I'm going to my brother's wedding. He lives in London. I'll see you when I'm back and give you a call, and we'll see if there's any work. And you're a bit shocked, and you go, well, hang on a minute, I need you for all. We've got a plan. Likely that's an employment relationship. You expect him to apply for leave. You can't just take August off because he's deciding to go to a wedding. There's some pre-approval that's required. Contractors can do that. They work in a contract of service, for service, not of service, and you are one of their many clients, and they may not be available for certain months or weeks during the year. The termination test is one where if you said to that person, hey, look, we're actually running out of work, the project's kind of finishing early, we're under budget, it's a great result, thanks, but from next Friday, mate, we don't need you anymore. And if they were aggrieved at that and upset, likely you've got an employment relationship, because they don't expect to be told, 14 days out, don't come back. So those are 2 sort of practical ways. If your gut's telling you, hang on, this isn't comfortable. But there are plenty of others. You're providing tools, you're dictating the hours of work, they only work for you. They're in your van, they're wearing your uniform, they're employees.
So we've spoken a number of times over the years about HR and sort of, I want you to tell us a little bit about sort of the problems you see in the market or the marketplace of employers, and sort of what got you into sort of solving problems around sort of what My HR does, and sort of the reasons why you
created
you think,
My HR.
Because what problems do you see that can be solved?
Yeah, okay. So, I mean, that's a really interesting question, Scott, because my background is all corporate. I've never been a consultant, sort of freelance person. And so in large-scale multi-site operations, the biggest I was responsible for at one stage was about 135,000 employees across 900 sites in Australia. And you get very used to honing good quality communications that allow those people out in the field to act in a way that is not just legally compliant, but is engaging to their employees and creates a good workplace. What I'd observed in the consultancy space and the small business space is that there was nothing really servicing these businesses in the same way. You either had very cheap or free DIY style templates, which I think there are risks to that, because they might be great while they're on the server as a template, but once they're in the hands of someone that doesn't really know what they're doing, they're associated with all sorts of risks. So it might be as fundamental as choosing a casual employment agreement for somebody that is actually permanent part-time. And that may be the best casual agreement that's ever been written by the smartest legal mind that New Zealand has ever seen. But if you've applied it to a permanent part-time employee and you're now paying that person 8% leave loading, and then you're letting them go on Friday and telling them there's no work for them next Monday when they've worked a set roster for the last 2 years, the quality of that agreement is completely irrelevant. And then at the other end of town, there are the sort of expensive consultancy services that for many small employers, they just didn't go near. because they felt it was too expensive and they didn't need it. I'm okay, I've been in business 20 years, I've only got 5 staff, I'm sweet, I'm not going to do it. So I thought, well, in corporate we do this. We engage lawyers regularly when it's required, and they absolutely have a place, and it's fundamental you have a good and a good employment lawyer for when you need them. But, and Linda will agree, I'm sure, in your day-to-day operations, you're not on the phone to your lawyer. Large corporates aren't on the phones to their lawyers. It would be cost prohibitive. And that's why lawyers have many clients, because they spread the work. So it's that day-to-day problem we're trying to solve in a way that's cost-effective but tailored to the needs. So I've taken that and I've applied it to building software, and it allows us to customise our output and advice to every single employer. So we write the employment agreements, we don't deliver templates. When a person is loaded into our software, my team review that, they make sure that the request is legally compliant, and we return offer letter, employment agreement, job description, tax and KiwiSaver forms, induction checklist, health and safety checklist, fed back through the software. So now that small employer of 4 people can issue a professional looking employment agreement fit for their purpose, because they're a scaffolder versus the web developer, and they are covered. And it covers all aspects, whether it's disciplinary, restructure, redundancy. And so I really saw a need where small employers weren't being serviced to that level of specificity, the needs that they have day to day without engaging expensive resources. And most of them therefore opted out. And I think this goes to probably what MB is seeing. There's a lot of non-compliance because people are just saying, oh, it's too expensive to comply. And after nearly 16 years of the Employment Relations Act and a law that said we need written employment agreements, we still have people that don't have them.
So does your system then help with sort of maintenance of employment records? We've heard a lot about what the obligations are around record keeping. So does that help?
Absolutely. And this is where the interface with MYOB Payroll is really useful, and I think same with health and safety systems, is that we house all of those employment records. Employment agreements signed, file notes, disciplinary records, performance reviews, anything relating to performance you can, or to employment, whether it's an electronic form that we've engaged in through our system, like performance reviews, or whether it's a physical form or a letter or a doctor's certificate that's been scanned and uploaded. Provided what is in the system is a true and accurate representation of the original and is legible, that is fine. The Electronic Transactions Act allows for that to be the record now, no longer the physical piece of paper.
Right.
So we host all of that for our clients. Everything, so the physical filing cabinet for personnel files is a thing of the past. It's in our system.
If I'm an employer thinking about hiring my first staff member, give me the cliff notes on what I need to do. Like, what is the stuff? If I'm going to not mess it up, what is the core things I need to be across?
First of all, be really clear on what the job is. It's so often we see, and it's a natural sort of human tendency, especially for business owners, because they're always in the detail of their business. I need my first sales rep because I need to grow sales, and they sort of go straight to the detail. The first thing is to step up and actually really be clear on what it is you need. Is it a sales rep, or is it a customer service person? And you help define that by defining what are the outcomes you want to achieve. What will my company look like in 12 years because of this role? Because if you do that, when you then hire somebody, you're hiring them into the right job and you're selecting the right person. So often employment relationship problems occur because the employer has got a job description off a mate or downloaded it off the internet, gone out and recruited for it, chucked it up on Seek, had an applicant who is probably perfect for that job, but that's not actually the job the employer wanted. And then the person starts, and halfway through the trial period they're going, this is not working out. And they blame the employee. This guy's hopeless. And in actual fact, he's doing exactly what you've asked him to do. What you're doing is you're defining your job on the fly. So that's so important, so often overlooked. So know the job, then you can recruit effectively. Do a thorough job of recruitment, right through to reference checks. Be really clear on that person you're bringing on. Then get that employment agreement out and in place before they start. My advice is you issue the agreement 7 days as a minimum, 7 days before their start date. So they have 7 days to review it, ask questions, get advice, and then they return it signed to you before their first day. And that means the trial period is robust. And then once they're on, induction. Please don't overlook induction and onboarding. It is so important, even in a small business. And that is the basics from what we're about, what our company is, where the toilets are, how you make a coffee, introducing them to the people in the office, through to then what is your job about? What do we need you to achieve? And support, so that through that early stage they hit the ground running. So don't overlook induction. It's not a, well, I've hired you, I'm basically paying for you out of my pocket because I'm a small business owner. Go out and do good things. Hands-off sort of approach. It just doesn't work like that, stick with them.
Thanks, Jason. Anything else imparting from my HR that would be useful for people to know? So if they want to know more about what you guys do, where can they go and find out more information?
Yeah, it's all online. It's cloud software as you'd expect these days. It's www.myhr.co.nz. And this year for us is building integrations with payroll providers like MYOB to make sure that those records now transfer seamlessly. We're expanding into Australia. We've got about 400 employers around New Zealand using us. Collectively, they employ 4,105 employees. And in industries as diverse as abseiling, scaffolding, plumbing, through to web development, media buying, accountancy, iwi trusts, charities, you name it. So it's an incredibly diverse array of clients, and all of our support is tailored to them.
So there you go, that's it from the panel of experts. I'd like to thank Jason, Linda, Erin, Mark and Chris from their various businesses for sharing with you some practical, legal and government tips and legislation that's about to come into force. Thanks. Okay, welcome back. So we've heard from the experts and they gave us a lot of really good information about not only what's happening in the legislation space, but also some really practical advice around tools you can use in your business to deal with health and safety and HR, and also from a legal perspective. What are some of those pitfalls you just need to be mindful of? So at MYB, we've also been recognising that some of this is really complex for employers, and we've been thinking about how we adapt our tools and solutions to really try and simplify what is quite a complex employment relationship you may have with your staff. So we're really excited to bring to market some great new products this year, and the one I want to talk about today is MYB Essentials Payroll. So we've launched an online payroll software tool. Previously, MYB Essentials had a payroll component. What we've done is we've broken it out and made it a standalone product. So now as a business, you can actually have your online payroll as part of your online accounting and payroll, or separate it out into a standalone payroll online solution. It's a straightforward 3 easy step product, really easy to use, and can really save time for someone processing a payroll. In fact, clients tell us they reckon they save 40% of their time by actually turning a manual payroll run into automated online payroll. Exciting couple of features to talk about as part of Essentials Payroll. One of those is MYB Pay Agent. So MYB is now a registered payroll intermediary with Inland Revenue. What this allows us to do is actually do some of the heavy lifting for you in the background. So we'll take care of your wage and IRD obligations for you. So as a business, all you need to do is take care of your pay, and once you've hit finalise, we'll be there in the background to take money from your bank account, pay your staff, pay the IRD, and then do all of the reporting that needs to be done for Inland Revenue. So job done. It really streamlines the process. And lastly, MYB Your Pay, brand new app to be able to be put into the hands of your employees. So this is a tool that you can invite your staff to, which will allow them to do their timesheets and also receive their pay slip. So once you've finished the pay run, they'll get a pay slip sent back to their app. The timesheet component's really useful. I was out at a cafe the other day and sat with the cafe owner for 20 minutes hearing her stories about the pain of doing timesheets. So MYB Your Pay is a fantastic way for your staff to be able to enter their timesheets during the week, be able to give you notes about when they're working or anything peculiar about any shift they're working on. And the great thing is that once they've submitted their timesheet, it pops up in the pay run, ready to process the pay run for whether it's a weekly, a fortnightly or a monthly pay. So again, fantastic tool for streamlining the runs that you have to do for your payroll, and really a great tool for you to really be thinking about what you can do to automate some of your business tasks. So one of the things we've also done is we've created a great set of tools and resources for you on our website, myb.co.nz/employer essentials. Great place to come and register firstly for your employer booklet. Tells you lots of things you need to know about your role as an employer. And look, here at MYB we see this as being more than just about payroll software. It's actually a bigger deal to be an employer. And what we're here to do is to is to really help you not only be a good employer, but actually be a great one. So from everyone here at MYOB, thank you.